to our channel Khatri Steno. Subscribe our channel for steno related dictation. So be ready for the High Court passage. Mr. Rajesh Kumar, learned counsel for the appellants, has drawn our attention to the terms and conditions of the appointment with regard to the service conditions of the respondent and also to the communications between the appellant number 1 and the respondent stop. Learned counsel for the appellants submitted before us that the High Court was wrong and incorrect in holding that the order terminating the services of the respondent was stigmatic. Stop. It was also submitted that it cannot be said that the appellant number 1 was biased against the respondent in taking the decision to terminate his services, as the board of directors was responsible for passing a resolution to the effect of termination of the services of the respondent after considering the entire records and performance and assessment report of the respondent. Stop Stenja. Ms. Sarita Dwivedi, learned senior advocate appearing for the respondent, on the other hand, submitted that a bare perusal of the order of termination dated 29/11/1999 would indicate that the same was stigmatic and therefore the High Court was justified in setting aside the same, as the same was issued without giving any opportunity to the respondent and without conducting any enquiry in that regard. Stop. It was also submitted that the decision of the Board of Directors to terminate the services of the respondent was the result of bias of appellant number 1 and also influenced by him, as he was very much present in the meeting of the Board of Directors in which the decision to terminate the services of the respondent was taken. Stop Stenja. In the light of above submissions made by the counsel appearing for the parties, we have perused the entire records. Stop. The respondent was appointed as executive director by letter dated 3/6/1998 on specific terms and conditions, one of which was that he would be on probation in the aforesaid post for a period of 1 year from the date of joining the post. Stop. It was also stated in para 3 of the letter of appointment that if the aforesaid terms and conditions are acceptable to the respondent, he may indicate the date of joining within 10 days. Stop. The respondent accepted the aforesaid offer of appointment along with terms and conditions appended thereto and also specifically accepted the position that he would be guided by the rules and regulations applicable to the appellant number 2. Stop Stenja. We have already extracted the rule position governing the service conditions of the respondent. Stop. The respondent was ordered to be on probation for a period of 1 year, and as per clause 3.2 of service rules, his performance during the period of probation was to be reviewed by the company, and that the company could extend the period of probation or terminate the service of the respondent at any time, or that at the time of probation period. Stop. On the other hand, clause 3.3 of service rules stated there has to be an order communicating the order of confirmation to the officers concerned after the end of the period of probation. Stop Stenja. In the present case, no such order of confirmation was passed by the appellant number 2 confirming the service of the respondent. Stop. There is no dispute with regard to the fact that the respondent continued to be on probation, which was extended for a period of 3 months. Stop. After making a total appraisal of his performance, a report was submitted to the board of directors by appellant number 1. Stop. The record also discloses that the board of directors held a meeting, and in that meeting they not only considered the performance assessment report prepared by the appellant number 1 but also perused the entire service record of the respondent and thereafter took a conscious and considered decision of terminating his service due to unsatisfactory work. Stop. The aforesaid decision of the board of directors of appellant number 2 was communicated to the respondent under the impugned order dated 29/11/1999. Stop stanza. Several contentions were raised by the counsel appearing for the appellants before us to challenge the legality and validity of the orders passed by the Calcutta High Court as also by the CAT. Stop. It was submitted that so far as the directions issued by the CAT are concerned, the only direction issued in the said order was to re-engage the respondents as casual laborers if there was vacancy in preference to freshers and those who rendered lesser length of service as casual laborers. Stop. It was pointed out that the respondents could not be appointed as casual laborers in terms of the aforesaid direction as there was a total ban on fresh appointments and therefore there was no occasion of giving any fresh appointment to any person and that no fresh engagement was made of any casual labor as against any vacancy. Stop. So far as the notes of assistant legal advisor and director general are concerned, it was submitted that no reliance could have been placed on the same by the High Court as they were internal communications and that they having been not been publicized, the same could not have been treated as official communication made by the competent authority. Stop stanza. It was further submitted that the same were only official notes in the course of processing of the files of the respondents and the same could not have been treated by the High Court as orders issued and publicized by the competent authority and therefore the disposal of the writ petition on the said notes was invalid and unjustified. Stop. It was also submitted that neither the CAT nor the High Court has any power to direct absorption of the respondents when they had worked only for 2 years and on the date when the original application was filed before the CAT they were not even working as casual workers. Stop. The further submission of the counsel appearing for the appellant was that the office memorandum which was issued in 1985 could not have been relied upon or made the basis for issuing orders in favor of the respondents, particularly in view of the fact that on the date when the aforesaid office memorandum was issued, the respondents had already been disengaged from service and were not working with the appellant number 2. Stop stanza. The aforesaid submissions of the counsel appearing for the appellants were refuted by the counsel appearing for the respondent, contending inter alia that since the note written by the Director General to which reference has been made by the High Court as also the aforesaid communications between the authorities were in favor of the respondents, both the tribunal and the High Court were justified in relying on the same for issuing necessary directions to the appellants. Stop. It was also submitted by him as has been held by the High Court that there was a clear discrimination for 10 persons who were similarly situated as the respondents were absorbed by the appellants whereas the respondents were denied similar benefits without any reasonable explanation for such hostile discrimination. Stop stanza. In light of the aforesaid submissions of the counsel appearing for the parties, we have considered the entire records. Stop. So far as the office memorandum dated 7/5/1985 is concerned, the same was issued by way of relaxation of the condition of recruitment of casual workers. Stop.